Constitution, the bill, any bill, a general suggestion, a formulated draft bill, a draft bill, the draft bill, a bill, and there was a word again repeated at the very end, the bill, which I've just drawn them just to try and analyze, because we seem to be all in agreement, the parties before you, that it's important to look at the textual analysis. So when I do the textual analysis, my conclusion was that the way the words have been used by the Constitution in those clauses can only mean that they are used in a singular form. Also suggesting, therefore, that when we prepare a draft bill to amend the Constitution, it ought to contain a single amendment. But if there is a need to contain anything more than one, it has to be something that is consequential, that arises from that amendment being made. Because it happens, you could amend one section and it touches on another one. But the primary amendment should be one. So that's why I want us to start on our analysis when we, hopefully I am praying to the court, when you do the analysis, to begin at that point, which will then assist us to reach a conclusion that a draft bill should contain one issue or one amendment. However, if the court also looks at that, it should not rest at that point. Also look at the findings and see that if an amendment is just one amendment, then when we go to the referendum, the voting should be on the amendment, that single amendment, in a way that allows the people to select just one item at a time. There is a possibility when you do an amendment, you may have then what I'm calling the referendum questions, whereby just a single amendment elicits the need to get responses from the people on more than one issue. I'll give an example. If there was an amendment to alter the presidential term, that kind of an amendment will require some responses from the people. Do we agree that we should alter the presidential term limit? That will not end there. We may need also to hear from them. Do you want to increase it? Do you want to increase the term, presidential term, or reduce it? Then there will be another question. How should that amendment be? Do we have a 5-year presidential term or 4 years? A 5-year term, that is, and then is someone entitled to getting one term only? So you can see that just one amendment can lead to more than one referendum question. So what I'm asking the court, by looking at my prayers, the main prayers in my petition, if the court can reach a conclusion that we should have a draft bill with one single amendment, it will be able to resolve the problem. If we have an amendment that is framed in terms of the distinct referendum questions, that will be able to deal with the problem. This issue that is before you is not theoretical, it's not speculative, it is based on a real issue. Before you, what has triggered the litigation, at least for all the petitions before the High Court except one, was the fact that there was an amendment bill, what we're calling the Constitution of Kenya Amendment Bill 2020, which, as we've said, contains 74 amendment clauses, but there could be many more amendments. If you analyze each and every clause, it could generate more than 74 amendments. So therefore, when I approached the court at that time, I'm informed by Article 22 of the Constitution that if I can, as a citizen who is doing his duty under Article 1 and Article 3, Article 1 and 3, to defend the Constitution, I have to approach the court and say, I am feeling that there is a threat on the Constitution, because if we conduct this referendum, we end up with a yes or no question on 74 amendments. It's dangerous. It's not good for the country. It will decimate the Constitution. And I'll give examples. When I looked at the amendment bill, as a citizen who is taking a vote, I'm just going to pick a number of examples. I saw a provision allowing a tax break. I would be very happy. And I think any entrepreneur out there would be happy to get a tax break. But as an advocate, I found another provision telling me that if we pass the amendment bill, then I cannot conduct election petitions until when beyond the Court of Appeal. That litigation ends there. And I found that is a limitation on the rights of those who litigate, because the provision is there. Matters of political rights should not be limited. As a litigant, they should be able to get the opportunity to litigate to the end. As a an advocate of the High Court representing them, that's my trade. I should not be limited to end my litigation in the Court of Appeal. When will I appear before you, Honorable Justices of the Supreme Court, if we end all the litigation in election cases at the High Court, at the Court of Appeal? So I'm concerned I cannot accept to vote for that kind of an amendment, but I am seeing the tax. So I'm being put in a dilemma as a citizen when I'm taking a vote on that kind of a bill. I look at other dangerous provisions that would have totally destroyed our judiciary, like the Judiciary Ombudsman, which was dangerous for our country, not just for the judiciary. So basically then I would like to highlight other provisions of the Constitution which should aid the court to reach a conclusion that we should always have separate, distinct referendum questions, and we should have a draft bill only raising, or rather containing only one single amendment. We begin with Article 32, which gives the people freedom of opinion. You are entitled to form your opinion, but if I'm given 74 amendments all in one document, what opinion will I form? If I have to still express my decision at the end, having been given more than 74 contradictory, confusing provisions, some of which I agree with, others which I do not approve of. I go to Article 33, freedom of expression. If you give me all of them in one document and you tell me to express my freedom of expression, I will not be able to exercise that freedom. If you give me this in a vote, Article 38, my political rights, when I'm seeking to vote as a citizen, and I'm just given all the options tied in on one ballot, it cannot be in line with Article 38, where I'm told that in Article 38, my freedom, the right to vote includes being able to vote in a way that, to be able to express my will in an election freely. It cannot be free if it is like that. Then I go to the general principles for the electoral system of Kenya at Article 81. They have been laid out. What are the principles? That the electoral system should be able to enable simple voting, efficient voting, voting that is seen as transparent and accountable. It cannot be transparent and accountable if you get 74 amendments and you are voting in one. It's like, I'll use a simple analogy. If we were to be given the 6 ballots that we usually do in our general election, and you're told you have all your presidential candidates, they are in one ballot, or rather they are classified, and you're told you have this presidential candidate and you have this member of parliament, all the way from top down the ticket, vote only once. How is that going to be, how does that sit with the Article 38 and Article 81? So basically what I'm telling you, the justices of the Supreme Court, is that the issue of the format of referendum questions and the draft bills, it strikes the heart of the Bill of Rights. And when you interpret the Constitution and Article 259, then you have to look at that. You have to look at whether the kind of thing that is before you will it enhance human rights, will it enhance fundamental freedoms of the people. As I come to closing this presentation, I would like to urge you, the justices of the Supreme Court, that what we are doing here is something, basically a point of inflection for our country. And as President Joe Biden usually says, it's on us. It's on you, the justices. It's on us, the advocates and the people, to comply with the clarion call in Article 3 of the Constitution, that we have to ensure that the Constitution is respected, upheld, and defended. I thank you, judges, and in case there's any question you would like to ask me at this point, I would be happy to take it, or I'll take it at a later date.
Thank you for your submissions. I think we'll reserve the clarifications later.
Thank you, Honorable CJ.
Yes. It is now 1:20. We will take a lunch break and resume at 2:30 to hear from the respondents. 2:30.
My Leader is an election campaign portal featuring aspirants' profiles, their agenda, parties, non-governmental
clarify a
organizations.
really small and harmless report I've seen in one of our dailies concerning yesterday's proceedings. I have seen it reported that 2 advocates sought leave and were granted permission to withdraw from the proceedings, and that Ochiel Dudley was one of those 2 advocates. I just wish to clarify, my lady, that Ochiel Dudley did not seek permission to withdraw and did not withdraw. He remained seated yesterday and has attended today as he will tomorrow. Most obliged, my lady.
Thank you. That is well noted.
Thank you, my lady.
2:30.
My Leader is the election campaign portal featuring aspirants' profiles, their agenda, parties, non-governmental organizations, service providers, among others. Find the Kenyan aspirants. We promote women aspirants. Wamama Oye! Get to know aspirants' profiles, agendas, and manifesto. Connect and go live with video, calls, and live chats. Find timely election and campaign news and updates. Partner with us in the 47 counties for a better Kenya. Our campaign services include web design, bulk SMS, short code, ringback tones, design and printing of campaign posters, t-shirts, lassos, banners, among others. We have developed a parallel vote tallying system to help you safeguard your votes through real-time SMS. Get listed today and reach more voters. You have no internet access? Do not panic. Our mobile app has an offline access. You can also send Siasa to 22204. Contact us through our website www.myleader.co.ke. My Leader. My Leader is the election campaign portal featuring aspirants' profiles, their agenda, parties, non-governmental organizations,